Thank you very much, Mr. Chairman. And let me say to my friend Senator Cornyn, I'm here. I'm here doing my job. And I came here because we're in the midst of what this nominee has characterized as an unimaginable crisis. I cannot imagine that I could go throughout the state of Texas or the state of Illinois and ask Americans who are concerned, worried, frightened by the current situation facing us with the coronavirus, what the highest priority of the Senate Judiciary Committee should be. We know what it is when it comes to Senator McConnell. It is this nominee. This nominee. Of all the things that we could be debating, things that are relevant to this crisis, we have been brought back here to debate this nominee. That's the point I wanted to make in my opening statement. I'm here. At some risk, I assume, maybe some danger, I'm here. And many of us are as well. And that's the point I wanted to make. So let me ask you this, Judge Walker. You've been very careful, and I've written it down over and over again, how you've referred to your responsibility when it comes to the Supreme Court decision upholding the Affordable Care Act. And only once or twice have you deviated from saying it is binding on you, quote, as a district court judge. So please clarify, how would it be binding on you, if at all, should you become a D.C. Circuit Court judge?
It would be binding on me in an absolute sense. Vertical stare decisis is absolute, and I would follow all precedents of the Supreme Court fully and faithfully.
But you said, and I quote, I will go where the law leads, I will go where the Constitution leads. Could you square that statement with what you just said?
Oh, certainly, Senator. The Constitution requires absolute fidelity to Supreme Court precedents. The Constitution outlines one Supreme Court and then the possibility of lower courts. And so in the judicial hierarchy, whatever the Supreme Court says, that's the law for a lower court judge, whether I'm on the Western District of Kentucky, as I am now, or if I'm lucky enough to be confirmed to the D.C. Circuit.
The problem we have, Judge, is that we expect of our judges honesty, humility, impartiality. You have not been the least bit impartial when it comes to the Affordable Care Act. Your legal or / constitutional contempt is obvious. You call it an indefensible decision, the decision upholding the Affordable Care Act. Indefensible, your words. At your own ceremonial investiture, with a Supreme Court justice standing by you, you mocked it. You mocked that moment when Justice Kennedy was told what the rationale was for the Affordable Care Act case. And now we're in the midst of a pandemic where the question is being asked by everyone, can I protect myself? Can I protect my family if I have to face this virus? That is a question that people face many times each day. And here you come before us asking for a lifetime appointment to the second highest court in the land, having mocked the law that basically provides an attempt to extend health insurance to more Americans. Do you understand the angst? Do you understand the concern that we have to put you in that position at this moment in history?
Senator, if I can speak personally just for a moment, I know your time is limited. When I was 2 years old, my mom had breast cancer. She's a breast cancer survivor. She's survived heart surgery. She has survived neurosurgery. I thank God every day that she was able to get the medical care that she needed, and I very much hope that every American is able to get the medical care that they needed. As a judge, it's not my job to define policy. It's my job to go where the law leads. And with regard to what you said about integrity and independence and judicial temperament, I think that question goes to why the American Bar Association said they were giving me their highest rating yesterday.
I've got a way to resolve this problem. Let me ask you if you'll consider doing this, put our minds at rest when it comes to what you just said and what you would do as a judge. In light of your public comments about the Affordable Care Act's constitutionality, would you commit to recuse yourself from any case involving constitutional challenges to the Affordable Care Act's provisions?
Senator, Section 28 U.S.C. 455 outlines when a judge should or should not recuse from a case, and I pledge to you today to follow that statute to the letter. I would also consult with my colleagues on the D.C. Circuit and the AO. There is a long tradition of judicial nominees not making a promise on whether to recuse from particular cases, because a judge has to take every case by case with an open mind, and the decision on whether to recuse about a case is a decision about the case.
Judge Walker, after 162 television appearances, after all that you've written and all you've said, it is painful to hear you say you have an open mind on the issue of the Affordable Care Act. I gave you your opportunity to clear this issue off of the agenda. You've chosen not to. I yield.